Good morning. I'm Ashley Still, the Dodge City Business Advisor for the Small Business Development Center. We're an economic development unit that helps entrepreneurs start, grow, or transition out of their business through trainings like this one, as well as one-on-one counseling. We're based out of the Southwest Kansas SBDC Center, which is hosted by Seward County Community College and is responsible for the 22 Southwest Kansas counties. The SBDC is a grant-funded program and then also funded in part by the SBA, Kansas Department of Commerce, Seward County Community College, which is where the regional director, Maria Dennison, and the business specialist, Magdalena Rivera, are based. My office out of Dodge City is hosted by the Dodge City Ford County Development Corporation. Today, we are collaborating with Davis and McCann. Local attorney Megan McCann is a native of Southwest Kansas. She graduated with her JD in 2008. I'm not doing a very good job of moving my slides forward, which also isn't working. She's a partner at Davis and McCann in Dodge City, with her primary focus being estate planning, trust administration, probate, real estate, Medicaid planning, and family and small business succession planning. Let me see if I get this to go. These are just some of the services that the SBDC can provide. And then I'll let you take over.
Okay, so where do I need to stand? Is there a certain place?
If anywhere in this general vicinity. Yeah.
Okay. All right. So I'm gonna warn you guys. I haven't done this one completely. I've got this designed to be somewhat interactive, and since I can't see you all, that's gonna make this a little bit interesting. So we'll see how this goes. So as was already said, my name is Megan L. McCann. I have been practicing out here in Dodge City. I grew up in Cimarron and have practiced out here for, I think, over 13 years now. So I do focus my practice primarily in the areas of trust and estate planning. That involves, particularly out here, we do a lot of business succession planning, in particular, a lot of the times with agriculturally based businesses, very much because of where we're located. And then I also do some Medicaid planning. I'm licensed in Oklahoma and Kansas both. So I wanted to start today by talking about estate planning in general. People are usually familiar with their businesses, but not necessarily, and familiar with estate planning, but not necessarily in how those two things interact and work together. So what is estate planning is kind of where I always like to start. Estate planning is actually a lifetime process. I have a lot of clients that don't think of it that way. They think of it as simply being something that happens and occurs after they're gone, but that is not the case. It's very much a lifetime process where I control my property while I am alive and well. So we'll talk about in particular what happens if I become disabled. That's a very important one when it comes to a small business. How I take care of myself and my loved ones if I do become disabled. How I give what I want, when I want, to whom I want, in the way that I want. So, what type of control we want to have over that. Obviously, the more planning that we do, the more control we will have. And I want to ensure long-term control of my property. Usually, in particular, my clients that have small businesses are very focused and worried about that because they are oftentimes the ones most concerned about leaving a legacy for their family members. So the goals of what I would consider a good estate plan or a small business succession plan, since those two oftentimes fit very much one inside the other, is to care for myself and my family, both during my lifetime and after I'm gone, to try to pass my assets as simply and easily as possible, save money. That's always a big one for people. I have a lot of clients that assume that the best way to save money is to not worry about planning because it's expensive to go see an attorney. I can say from experience, my clients that usually end up having the biggest headaches and the most costs and expense are the ones that don't do the planning ahead of time. So that is usually one of the goals of a good estate plan, is to try and save money and set things up in a way that that saves the most in your financial side. So We also want to maintain control over the business that we've worked hard for. So, all right. So what are your fears? And this is the part that I usually have somebody here to be a little bit more interactive with me. So feel free, if you guys are on Zoom, you can type them up, and I think we can see them here, so I can answer those. But in terms of a small business, you know, a lot of people usually have a list of things that they're afraid might happen if something happens to them, whether it be death or disability at some point. So I have a few kind of somewhat comical examples that we've thrown together of things to keep in mind or think about. So the first one is losing your small business to your partner's creditors. So your partner has a son-in-law named Fred. He hasn't had a job since 2012. He belongs to a religion that you consider a cult. He sells t-shirts at concerts by a band called Fish. You suspect he's fond of chemical substances, and he thinks it's great that he has a rich in-law whose business he will inherit, and you'll run for him someday because he's not going to actually do any work in it. So that's something we can plan around. Or losing your business to your partner's prodigal son. So your partner's son, Marvin, has started 3 business deals and 2 real estate deals in the last year. They've all failed. He's asked you and your partner to financially back each one. He's also asked your partner to bail him out of each one. He recently filed for bankruptcy again, and he can't wait to inherit from your partner so that he can help you run your business. And then the last one would be more of the situation of maybe a sole proprietorship or something that you and your spouse have together, and maybe don't have employees, but losing your business to your spouse's next spouse. So Elaine, your husband's next wife. So in the months since your death, she's brought home cooked meals to your husband 6 times. Each time she visits, she wears a skimpier outfit. She can't wait to redecorate your office space and thinks that your business that you had hoped to leave for your children to run should just be sold off to pay for her expensive European vacation. So how can we avoid some of these types of things? And obviously these are comical, but they can lead to something much more serious and real. So the only way around them obviously is to put a plan in place. So I wanted to start by talking about the types of small businesses that I most often see in my office when we're talking about business succession planning. The first one is the single owner, single member, sole proprietorship. That can be something that is like an LLC that's taxed as a disregarded entity even, but basically we have one owner. The second type is a partnership where we just have 2 individuals, whether it be a partnership that is like a formalized partnership where we have documents in place, or one that is just, we have a tax ID number and it's just my partner and I, and that's just how we operate, and we don't have anything in writing. Those are my least favorite, but I have several of those. The multi-member business, so whether more than what I'm talking about or referring to there, are those businesses that have more than 2 individuals that are involved in the ownership. And then whether those businesses are family businesses or whether they are non-family members, because how we plan for those businesses makes a large difference depending on whether we have a family business versus whether we have individuals who are not related parties that are owners in the entity. So I usually just like to go through and break down each one of these a little bit. So the first one is the first one that we were going to talk about is the single owner individual. So sole proprietorship. The things that people most often need to think about with the sole proprietorship are, will that business continue? Can that business continue? So this is a situation where we absolutely need a plan for the business, even if it's that the business will fold once something happens to that individual. Most commonly with my clients, when we do planning for a single member sole proprietorship, that plan is set up through their estate plan. So a lot of the times we don't have a separate document for the entity itself, and instead we just have the plan for that entity done within their estate planning documents, whether those documents be will, trust, in some cases a beneficiary plan. We'll talk about each of those today. If I don't run out of time, I've got it set up to do that. So a lot of things to keep in mind with a sole proprietorship. Can the business continue upon your death? What about your incapacity? So my business is a good example. I am obviously, as an attorney, because I have a professional entity, and I actually am currently the sole owner of my business. I bought my partner out this last year. She's semi-retired now. And so for that reason, with my type of business, you have to be a licensed attorney in order to continue in that business. That can be, with lots of businesses, that's not uncommon if we have a professional entity. So what that means is if I become disabled or incapacitated and cannot continue my business, or if I die, I have a certain amount of time that's given to me by my licensure group here in the state of Kansas, that business has to be wound up or that it has to be moved on to somebody else. So those are things that are important for if you go see your estate planning attorney and you're putting a business succession plan in place and your sole proprietorship, those are things that are important. Other things to keep in mind is, do I have the type of business that maybe it's not because of my licensure that I have, but maybe it's just because I do something that's so specific as to me that not just anybody can do it. Can that business continue on after my death or incapacity? The answer to that may be no. And if it's not, then what is your plan for your family? And that's where that really comes into the estate planning side of things as well. Can the business be sold? Some businesses are a lot harder to sell than others, and location oftentimes has, as those of us here in Southwest Kansas know, has a lot to do with that. It's not easy to find professionals out here, and so that can be something that can be difficult. And so once again, having a plan in place in the event that business can't be sold is always a good idea. Key man and disability insurance, we'll talk a little bit more about some of these items, but key man insurance is a big one for my sole proprietorships. Life insurance is something we'll talk about a few different times today. And it's very important in regards to any sort of business succession plan, or it can be. The reason for that is it tends to be less expensive, and it's an easy way, oftentimes if somebody is to pass away, to have money there that's available that we didn't have to go to a bank to borrow from, or that we didn't have to worry about trying to finance something in order to have cash there to pay to wind up that business or keep that business going until it's sold, if the case may be. Disability insurance is somewhat the same. If this is my sole proprietorship is something that I have a family member or that I'm hoping my family will want to continue with, one thing to keep in mind is, will they want to? I have a lot of clients that come in and they just assume that the kids, the farm is what most often comes to mind out here. But I have a lot of clients that just assume the kids would never want to sell the land. And I'm going, well, I get that, but none of the kids live even in state and they may not have a desire to keep it forever. And oftentimes it's not something they've ever thought about, let alone discussed with their family members. And then is there someone who would even be able to run it or have a desire to run it? So those are all things we want to look at too. There are a couple of different buyout options that we most often see when it comes to a sole proprietorship. One that is probably the most common one that I do is a first right of refusal. That's oftentimes going to show up in, and I'm losing my screen here. Sorry. Do I hit something here? Okay. So first right of refusal is probably the most common one that I will do in sole proprietorship in somebody's estate planning documents, where we'll say, hey, we've got somebody that we think is going to have an interest in this business and we want to give them the first option to buy it. That's the most basic type of first right of refusal. We can do even more detailed from there. For example, we can say what price we want them to be able to buy it out. And we can say if the person selling it or if our estate is selling it, whether they're going to have to finance that sale or whether the individual buying is going to have to finance that. So those are our most common options with a sole proprietorship. Partnership is the next type of entity that I most commonly see in my office. And a partnership agreement, this is the one I said earlier that, of course, I've had a lot of clients that come in and they have a partner and they don't have anything in writing that says they have a partner other than a tax ID number and the way they file their taxes. There really isn't anything formalized. Those are my least favorite. What a lot of those clients don't realize is Kansas law says that if I have a partner and we don't have any formalized written agreement that says otherwise, and I die, that my partner doesn't just get to continue on with that business, that partnership dies with me. And that can be a big one for a lot of people. So extremely important to have a formalized agreement. whether it be just a basic partnership agreement or whether it be something where you've gone to the extra steps of putting an entity in place like an LLC, where you have formalized agreements between you and your partner to be able to buy one another out. Those are the other things to consider. If something happened to me, would my partner want to continue, and would they be able to? You know, a lot of cases, depending on the type of business, the nature of the business, or the size of the business, if one partner were to go, the other partner just couldn't handle the work, or maybe wouldn't have a desire to. So important things to consider and keep in mind. Can my partner afford to buy out my interest? So just because my partner would want to buy out my interest if I became deceased or incapacitated doesn't mean that they would be able to afford to do that. And so a lot of my discussions with clients will center around options to be able to buy an individual out. We're going to talk and spend more time on probably the most common option that I see with clients, and that is a buy-sell agreement, and look at that here in a few more slides. And then finally, does my partner, you know, if something happens to me and my partner can't afford to buy me out and my interest passes according to my estate plan, which is why estate planning with business planning is so important, does my partner want to work with my family members? So we talked earlier, remember, about the prodigal son. For example, you know, if I die, does my partner have any desire to work with my family members? And do I want to force my family members to work with my partner in the same instance? So the next most common type of business I see is just a multi-member business. Typically, most of my small businesses, even my multi-member businesses, we're usually going to categorize those as clients where we typically don't see more than 10 to 15 owners at the absolute most. And most of my small businesses are fewer than that. But in that particular case, we want to look at several things. Your organizational documents, how do they read? And what I mean by that is, do we have buy-sell agreements in place? Do we have an operating agreement with an LLC, for example, that says how interest can be transferred? Can interest be transferred? Are they allowed to go to family members? When somebody dies, do they have to first offer that interest to the other partners, or can they leave it to other individuals? So if we're talking about estate planning and we have a business or we have multi-members, that's one of the first questions I'm going to ask a client is, hey, I want to see copies of your organizational documents, because it's very important for me in the term of doing estate planning to know, are we able to do what my client wants to do in their estate plan with that partnership or with that multi-member business interest? Sometimes the answer is no. We have to rethink that. So voting versus non-voting interests. What I mean by that is a lot of the times clients will have a setup that will allow them to leave an interest to a family member if they pass away in a multi-member business, but sometimes that family member won't have voting rights at all, or at least right off the bat, without the other members giving them voting rights. And what we mean by that is they have the right to receive the income that interest has earned, but they would not have the right to have a say on how that business is run. And that's a really common provision that you'll see in just about any entity that we do in our office, because we usually want to try to give the initial members a little bit more control over what happens with that interest. This type of business is probably the one that is most likely to continue in the event of a death or incapacity, just because we have multiple members usually to continue that on and keep that going. Obviously, the fewer people we have, the less likely it is that we're going to be able to continue that entity versus the more individuals that we have. But one thing I have clients that they sometimes haven't thought about is, you know, does your family need the cash from that business? Do they need to be bought out in order for them to move on? And thinking about how that business transitions is just as important as thinking about what happens with your family. And so that's why both branches are vital, really, to consider. And then once again, do your partners want to work with your family? And we talked about that a little bit with the partnership interest. If it is something that can be passed on to family members, do your family members want it? And do your partners want them to have it? So all of those things make a difference. And that leads us into buy-sell agreements, which are probably the number one document that we prepare in my office when it comes to small business succession. This is the most common document that we'll end up preparing. So we'll talk about 4 things in regards to a buy-sell. The first is what it is, what I mean by a buy-sell. The second is how do we fund it? How do we pay for it? How do we make sure there are funds available to follow through with whatever that buy-sell agreement tells us to do? Of course, how do we determine the value of the business? That's a very important one because some businesses, particularly the smaller entities that are run by 1 or 2 people, oftentimes the value of the business is in the individual. And that can be extremely hard to then determine the costs of the business when you no longer have that person or people available to you. And then the final one is just triggering events. So anything, the most common ones that we think about are things like death and disability, but there are other triggering events that it's important, I think, for clients to be aware of. So what is a buy-sell agreement? Buy-sell agreement is a written document. It's either been signed by the owners or it's agreed to by the owners. And what I mean by agreed to by the owners is most of my buy-sell agreements that I put in place are going to have a provision that say that any new owners after my original owners that enter into that buy-sell agreement, any new owners, or whether they are owners that have received via inheritance or owners that have bought in some way, they are also automatically tied in and agree to that buy-sell. It's one of the things we will have them at the time they buy in or at the time they inherit, they sign that they're also bound by that same agreement. It provides for what occurs with an owner's interest in the business in the event of certain triggering events. And as I just said, we'll talk more about what those triggering events are in a moment. It usually has some sort of funding mechanism or a way for the individuals to, if they're required to buy something out, that they have a way to do that. And it will include typically a valuation mechanism for how we're going to value the business. It is not uncommon for us to use different valuation methods for different triggering events. And I'll explain that more in a second. So how do we fund a buy-sell agreement? The most common mechanism that my clients use to fund a buy-sell agreement is probably with insurance. What I mean by that, I'll give an example. My law partner and I that just recently retired on me, we had a buy-sell agreement in place that was very basic before that happened, that said we had, the company bought a life insurance policy on me, the company bought a life insurance policy on her, and basically the requirement under that agreement was that if I passed away, my insurance policy would pay into the business, and that had to be used to buy out my family. Like I said, insurance policies, depending on our age and our health when we put them in place, usually a very economical way to do things, not to mention having the business own that insurance policy and pay for that policy is usually a tax write-off, which all of my business clients are usually after when they can be. That is not always an option for some of my clients. Some of my clients, given their age or their health status, they're just not insurable. And so it's not always an option that we have available to us. Other times I'll have clients who they may qualify for some insurance, but not enough. And so we move into other options. Seller financing is also a really common one. Seller financing, an example of that would be if I have an agreement that says, if something happens to me, my interest has to be in my business has to be sold to my former law partner, and my family has to finance that sale over time. So what I mean by that is it will say, typically they'll have provisions that will say, like my spouse is required to sell that, but the business buys it out over like a 10-year time frame with annual payments and interest at 2% over the applicable federal rate or something like that. So that's what we're referring to when we say seller finance. We're saying, hey, whoever it is that has to sell this interest, regardless of what type of triggering event resulted in that sale, they have to finance it over a period of time. And that way, the idea behind that is to avoid the partners who are having to buy it out or the business that's having to buy it out. It avoids them having to go into debt in order to buy out that interest. A bank loan, obviously, we're all familiar with that. And then the last one is a combination of all of the above. So we'll talk a little bit about this in a minute when we talk about valuing an interest. But oftentimes I'll have clients who will have an insurance policy, and that insurance policy will cover the bulk of the buyout, but sometimes it doesn't cover it all. And so in that event, we'll have a second mechanism in place sometimes whether that be that, oh, we don't have anything, and so they're just going to have to go get a loan for the rest, or that we're going to require the seller to finance the rest of the sale that's not covered by insurance. Okay, so how do we determine the value of the business? There's several ways to do that. The most common is the fair market appraisal. That is literally where we appraise the assets of the entity. We'll hire somebody oftentimes to come out and do a valuation on the business. That can be expensive. And usually in that particular case, when I have clients using that, it's going to be in the event of a death, or we have a required buyout, or if we just have somebody wanting to buy out just a basic, I want to sell to any buyer, and I'm able to do that under my agreements, and I have a third party buyer who's interested in buying, and it's just a very basic transaction in that case. Book value is probably my next most common. Book value, when we see that most often in our office, is when we have a transfer that is required from an involuntary transfer. Basically, like if I have a partner who's getting a divorce and I've got a provision in my buy-sell that says, hey, I'm not going to deal with your ex-spouse. And so we've got a mechanism in place to buy that individual out at a lower value. And that's what the book value is typically going to be. It's essentially going to be what you're using on your taxes. Usually going to be significantly less than fair market value. Sometimes we see a set value. So earlier when I mentioned businesses, particularly those that have, maybe one owner or two owners, are hard to value because the value is oftentimes in the individual. It is not uncommon for clients to do a set value, particularly if we have insurance that's funding. My partner and I that I mentioned earlier would be a good example. Our buy-sell agreement that we had in place prior to her retiring, said that the value of my interest was going to be the value of my life insurance policy, and the value of her interest was going to be the value of her life insurance policy in the event of death. So we're just setting that number, and that way we know the cash will be there to buy one another out, because we have one of those entities that without the attorney, you can't have the law office. So those kind of things make a difference. And finally, just a value dependent upon a triggering event. And that's what I talked about earlier, how we will oftentimes use different values for different triggering events. And I'll explain that here a little bit more in a second when we talk about triggering events. So the most common triggering events that clients usually think about and are aware of when we're talking about business succession planning and estate planning are what happens in the event of their disability and what happens in the event of their death. The ones that they oftentimes don't think about but are equally important are things like retirement. So as I mentioned earlier, if we have an entity that has an individual who is required to have some sort of special licensure in order to be an owner in that business, and an individual retires and gives up that license, they can't be an owner anymore. So that would be an important triggering event for us to have. A lot of my entities that I've set up for my physicians around here, oftentimes they will have retirement be a triggering event. If somebody's not actively involved in the practice anymore, they don't usually want them to be able to be an owner any longer. My farming entities, retirement is usually a less important one, but it oftentimes depends on the entity specifically. Involuntary transfers is the big one that nobody likes to talk about, but it is probably the most common triggering event that is the most important in a lot of cases. So involuntary transfers are usually going to be I've had a partner that's had to file for bankruptcy. They're having a creditor issue. They've been sued by somebody and it's causing a financial issue for them, or divorce. Divorce is probably the one we most often see. Those are a situation where we will usually see a different valuation method that is a lower valuation method, particularly with like a bankruptcy proceeding. We're usually going to have a lower valuation method written into the buy-sell agreement so that individual, that bankruptcy trustee, for example, can be bought out at a lower amount, something that's not going to hopefully bankrupt the company. And that's also when we will oftentimes have it required that involuntary transfer has to be bought out over time so that the business doesn't have to go into debt in order to buy out that individual's interest. So, and involuntary transfer is the one that a lot of times people don't think about, but nothing's gone wrong. We just want to be able to transfer our interest to our business. Maybe we ourselves are ready for retirement. Maybe we've got a child that we, or somebody else that we want to bring into the business, and we are voluntarily transferring some of our interests in the business. And so with the voluntary transfer, I kind of want to lead into talking about some estate planning options. How are we on time?
You have an hour.
Okay, so we're good still. So I wanted to use that to kind of lead into talking about our estate planning options and how those work in conjecture with transferring our business and ownership interests that way. So there are 4 very common estate planning. First one is to just do nothing. And I have a lot of clients that come to me and that's exactly what they have done, is absolutely nothing. Beneficiary planning would be next, will-based planning, and finally trust-based planning is where we'll end. So doing nothing. The plan for doing nothing on your estate planning is about as good of a plan as it is if you are doing nothing on your business. You have no plan for anything, whether it's death, whether it's incapacity, doesn't matter, you have nothing in place. Because of that, you are guaranteed to have a probate in the event of your death. If you haven't done any planning, then the only thing that we can do is go through that probate process with the court to get everything transferred. That is expensive and very time consuming. I am a big believer that nobody wins in court but the attorney, and I don't litigate, so I can say that. But basically, it is always the most expensive. It's ironic, I think, the number of people that don't do anything, assuming that that will save them money. And ultimately, that is what, in my experience, usually costs the most. And is if you're a person who would want your small business to continue in the event of your death or incapacity, this is the way that it is least likely to. It is you have zero control. And then this is also the way that you most likely end up with a potential guardian in conservatorship. That is, of course, in the event of your incapacity. Guardian in conservatorship is where we go to court. Guardianship is somebody appointed to take care of your person, basically make things like healthcare decisions. Conservatorship is the person who is appointed to take care of your finances. And obviously, with no planning in place and nothing in writing, you don't get to designate who that is, how those items go, what happens to that business. It is all run through the courts and according to the Kansas law. As far as when you pass, if you have done no planning, then everything passes according to what's called the laws of intestate succession. Here in Kansas, what that means is that if I pass away and I have nothing in place, everything I own goes 1/2 to my spouse, if I have one, and 1/2 to my children. I have a lot of clients who are under the impression that if they have, particularly if their children are still minors, that at the event of their death, everything just goes to their spouse. That is not the case. And instead, what will happen if you have minor children and you pass away and have no planning, not only does your property go 1/2 to spouse and 1/2 to children, but we then have to set up conservatorships typically for each of those children. So like in my case, I have 3. Talk about expensive. We'd have 3 conservatorships to set up for each of my children. That is because in Kansas, if a child inherits property totaling more than $10,000 in value and they are a minor, it is required to be taken care of through a conservatorship through the courts. So not my choice or my favorite type of planning, particularly for those that have small businesses. It would definitely be my least favorite. The next one is beneficiary planning. This is the cheapest form of planning. I will oftentimes tell clients in my office, which is always attractive for them. I get it. You don't need the attorney's help for very much. You do most of it on your own. However, there are several downsides because we still don't have a written document. So beneficiary planning, a good form of that would be if I own property with my spouse in what we call joint tenancy, joint tenants with rights of survivorship, meaning that if I die, my spouse has to do is file a death certificate and that property automatically passes to him. It sounds real nifty and can be, I mean, it avoids court after death. And so that part's all really nice. But without a written document, there are several fallbacks, particularly if we've got a small business situation. For one thing, there's no tax planning that way. And if we need tax planning, that can be a real problem. And I'll talk a little bit more about tax planning if we have time here at the end today. There's no contingency plan. So what I mean by that is my clients that choose to do beneficiary planning, if they have property that they have left to their children via beneficiary designation, and one of those children passes away before them or predeceases them, then there's no contingency plan as to what happens to that child's interests. One of the best examples I can think of, I had a client who years ago had an attorney put in place for them. He and his wife had done some estate planning with an attorney who thought it would be a good idea to do what we call a life estate deed. And it was on some minerals. And basically what that deed said is that my clients would continue to have all the income from those minerals during their lifetimes. And then after their death, that went on to their two sons. Well, sounds fine until one of their sons died before them. And that's irrevocable in that particular case. So there was nothing they could do to get their minerals back. That son who passed away had a spouse, but no children. And that spouse then also passed away, and everything went according to the spouse's will, which since they had no children, they were left to a bunch of random cousins and some charitable beneficiaries. So that's a problem. We talked about contingency plans here, but contingency plans could be things like, what if my spouse remarries? Do I want to have a plan for that? If I have a child who is on government benefits or who later qualifies for government benefits, and having received my small business interest is going to get them kicked off of their benefits, and they're going to have to spend down that asset. There's no plan for that with beneficiary planning. No planning for minors, and then nothing for asset protection. And we'll talk more about asset protection here in a little bit. If I have done beneficiary planning with just a spouse, a lot of the times, if I don't need tax planning or anything, that's fine until my spouse and I die in a common accident, and then we're back to no plan again, like what we had before. And then once again, you have no designated representative since we don't have a written document. So we have nobody in place to say, here's how I want my assets taken care of, here's who I want in charge of them. If we want to do something like we talked about earlier, like a first right of refusal for a child to be able to buy a business interest or something, we don't have that with beneficiary planning because we still don't have that written document. And then there is no control, once again, without a written document. So beneficiary planning, not usually something I recommend for my clients who have small businesses because there's still not enough control. We usually need that written document. So will-based planning. So with a will-based plan, we get better. The nice thing about a will-based plan is we now have a written document. With a written document, we can do a lot more. So we can plan for a remarriage, like I talked about earlier. We can plan for state taxes, like do tax planning. Yeah. Somebody say something?
Yeah. Maria, can you mute your computer?
Sorry. No, I just wanted to make sure somebody didn't have a question because I'm good to stop and answer those if we need to. We also can plan for government benefits. It's not my favorite way to. We can do something called a special needs trust within a will-based plan. It's a trust that allows an individual to still qualify for government benefits and receive their inheritance both. I don't love doing those through the courts. Anytime we do them through the courts, it's expensive, it's time consuming. It's just not my preferred way to do them, but we can do them within a will. And then we can plan for minors again within a will as well. Will-based planning is typically cheaper to set up than like a trust-based plan, not quite as inexpensive as a beneficiary plan, because once again, the more work that you're needing, the more expensive you can get, obviously. But it is not horribly expensive to set up, but after death, a will-based plan tends to be extremely expensive because with a will, you are once again planning for a probate. That is probably the most common misconception that I hear from clients in my office. They will come in and they will assume that because they have a will, they are avoiding probate, and that is not accurate. With a will, you are planning on a probate. There's nothing wrong with that, but that is the case, and that is the court process. The way that process works is that after somebody passes away, we have to file that will with the court, and we'll ask that the court allow that will to be admitted for probate, and we will also ask that our executor be appointed. It's not an automatic, and I have a lot of clients that will call me and say, well, I took the will into the bank and tried to do something and they wouldn't let me. Yeah, that's because the will doesn't do you any good until it's filed with the court. So that's part of the reason why we call this a death plan. Nothing happens until after you've passed and somebody's filed those documents with the court. There is no privacy with a will-based plan. Anytime we're in court, it's all public record. I have some clients that really bothers, and then I have others who say, I'm dead, what do I care? Personally, I think it may become a bigger issue at some point. The reason I say that is Kansas has now gone to where we have to do all of our court filings online now, all across the state, and they're actually in the process of implementing one system in order for us to be able to do that. I could foresee right now, in order to see that online system, you have to be an attorney. And actually, even as an attorney, I have to call the court and be added to a case to see those documents. So the only way to publicly see somebody's will-based plan and all their assets and everything that was filed and record with court is to go down to the court or to call the court and ask to be able to do that. But where we're going to all online systems, I could very easily see a day where you're able to search online just as a third-party layperson for something that's been filed, just like you can now with tax records. So I'm one of those that I do think there's a chance that may become a bigger issue for people at some point in the future. If just anybody could do a quick internet search and pull up what's called your inventory, which is the second big thing that gets filed with the court in a probate that has all of your assets and all of their values. Particularly with my clients that have small businesses, that's a big one. They like that privacy a little bit better sometimes. A probate tends to be lengthy is the next thing. Our average probate, so probate in Kansas cannot be closed out for at least 6 months. We are required under law to have it open for at least 6 months before we can close it out and have the executor dismissed. However, the average time for a probate, any attorney is going to tell you, is usually going to be more like 9 to 12 months. So anytime you're longer, you're more expensive once again. And it is more contestable. Once again, with the will-based plan, we've got something that we are already planning on having filed and in open court. And anytime you're already in open court, it's that much easier for somebody to contest. But the upside to will-based planning, like I said, is we do get some control that way because we have that written document. So a lot of the things that we were concerned about with our terms of small business succession planning, we can do and provide for within a will. I will often tell clients there's slightly less control here than what we do with the last type of planning we're going to talk about, which is trust-based planning. The main reason for that is with will-based planning, we're using our probate codes, and our probate codes in Kansas are just, they're kind of antiquated. I really wish they'd update some things. They've just been around forever. And for that particular reason, they have not kept up as well. And we get more flexibility with the last type of planning. So the last type of planning is trust-based planning. Trust-based planning we call a life plan. The reason for that is with the trust-based plan, the moment we sign it, it starts working for us. And for that reason, we say you get more control with the trust-based plan than you do with the will-based plan. So what I mean by that is with a will-based plan, if I own all of my assets just in my name, and I'm driving down the highway and I'm in an accident and I become incapacitated, then we have to go to court and do that guardian conservatorship we talked about earlier. And I have no say on who that is or how those assets are taken care of. It's all run through the court and decided according to a judge and statutes. With a trust-based plan, the idea with the trust is, with a trust, we do something called funding, which is where after we put a trust in place, we will retitle assets into the name of the trust or make sure that those assets flow through the trust upon death, depending on the nature of the asset. So if the same thing occurs and I own most of my assets in my trust, I've already said in that document, if I become incapacitated, who steps into my shoes and how those assets are to be utilized for my benefit while I'm still alive. So we do get a little bit more planning and more control that way. With a small business, that can be a big one. It tends to be more flexible and amendable. I will oftentimes tell clients with a will-based plan, I'm usually if we're making changes, most of the time, I'm going to scrap that will and do a new one. We can do something called a codicil with a will, which is a small change. It's similar to like an amendment for a trust. And every once in a while, if it's something real basic, I will do one. I'm not a huge fan of them. And if we have a big change, I'm usually going to scrap it and do a new one with a will. The reason, I always tell clients, it's not actually because I want to just charge you for a brand new will every time, believe it or not. It's actually because I've got a document that, as I said before, I'm planning on being filed in open court. And that in and of itself makes it more easily contested. And I don't want to add fuel to that fire. I don't want somebody to be saying, well, mom changed her mind about me as executor. There was clearly undue influence going on. If we don't have that change filed, nobody sees it and it's nobody's business kind of thing. Whereas with the trust, we have a document that we intend to remain private, outside of the courts, and for that particular reason, we'll just usually do small amendments to it. So it tends to grow with us. We also get a lot of flexibility with it. Remember how I said how we're run off the probate code with our wills? That makes them a little bit less flexible just because of the nature of those laws. Our trust-based plans are run off of a set of laws called the Uniform Trust Code, and that actually is a much newer set of laws, and so it gives us more flexibility and more options, which with my small business clients is usually a big one, because they typically want to have a little bit more control, particularly over what happens with those business interests and how they want those to be able to go. I will oftentimes tell clients that with a trust-based plan in Kansas, as long as it's not illegal or unethical, we can pretty much do it, which is too many options for some of my clients. So there's the ones I joke around like to come see me because they're in like 6 times a year making changes just for the heck of it, it seems like. So nice thing with a trust-based plan, once again, we have that written document like we do with the will, a little more flexibility, but we also avoid the probate like we do with beneficiary planning. So that is one of the perks of that. That is the document that when my clients say, oh, so-and-so passed away, how do I get access to their bank accounts? Well, if they're in the trust and you're the successor trustee, that is when you truly can just take the document, go into the bank and have access. So that it makes it a little faster that way. The biggest downsides to a trust-based plan, I usually will tell clients, I think are about twofold. The first one is it's more expensive to set up. So because we've got all of the funding documents that were talked about earlier that have to be done at the time that we put the trust in place, that makes it more expensive. I tell clients it's oftentimes like doing your own probate. It's still cheaper because you're here to tell us what your assets are and help us get them, make sure everything gets transferred into that trust. The flip side is unlike the will-based plan, which the will-based plan is much less expensive to set up, but then much more expensive to probate on the other side. We flip that with the trust, and so they are much less expensive to administer. I have some clients, I call them my handholders, that we end up doing everything. I mean, we basically act as the trustee. They'll bring a beneficiary or a claim form for a life insurance policy into my office and have us fill it out even. But most of my trustees end up taking care of just about everything themselves. We typically will have 1 or 2 meetings at most to answer some questions, and then they kind of take it and run from there. So that can be nice, particularly if we have a small business. It keeps things going. We don't have any wait time like we do with the will, where we're waiting for somebody to be appointed by the court. It's immediate with the trust. Somebody steps in and they can immediately take over and continue to manage things the way that we were previously. So some of the things that we can easily provide for with trust-based planning, remarriage, government benefits, minors. The asset protection is the one I do always like to mention. I have a lot of clients who aren't as familiar with that. Kansas is a state that's actually very favorable for asset protection. An asset protection trust is a trust that I establish for a third party through like my own trust-based plan. And so I'm a good example of that. If I have a trust and my trust says, hey, upon my death and my husband's death, my assets get split 3 ways for my 3 children and get held in trust for my children. And my children, usually then what we'll say is at certain ages, they can be their own trustees. Well, as long as my child leaves the assets that they've received in the name of their trust share under current Kansas law, it is protected from their creditors. So if they take bankruptcy, if they get divorced, if they get sued, we've got protection in place for them. I do always point out that with the type of trust I'm talking about here, you'll hear it called a grantor trust, a revocable trust, a living trust. Those are all the same thing. If I put one of those in place for myself for estate planning purposes, I have no asset protection myself with that type of trust. And that's something I have a lot of clients who get confused about. I can't, in Kansas, set up a trust for myself, put my assets into it, and then say, oh, my creditors can't get to them. And the big one I always get asked about is the nursing home. That includes the nursing home. So I can't protect my own assets that way, but I can do that for a third party like a child. And when we're talking about a business succession plan, earlier we talked about Marvin, my partner's son, who loves to be a wheeler and a dealer, but has clearly shown he can't manage his assets. Then this is something that could be very beneficial, because that's the type of individual we could, if we wanted them to still have it, we could set something in place for them that even put somebody else in control of that if we felt like we needed to. So this comes down to, once again, we have the most control. And this is the most common recommendation that I have for my small business owners. I don't ever push somebody into one plan or another. I always like to say I'm low pressure. I always feel my job is just to give you the options, the upsides and the downsides to each. But most of my small business owners are the ones that are in the most need, as far as needing to have that control to say what happens in the event of their deaths. And so the trust-based plan tends to work really well for that. And that's one of those situations, if we have one of those buy-sell agreements we talked about earlier, we will make sure we have the estate plan set up in such a way that those things flow together and match and don't end up counteracting one another. So. And then the last thing I wanted to spend a little time discussing, if we had time, is what we call, it's just some tax issues. So it's one of the most common questions that I get in my office is, what about taxes? How is that going to look when I pass away? Particularly with my business owners, that can be a big one. Usually that small business is the largest asset in their estate most of the time. And so knowing what might happen tax-wise is a big deal. So I did want to spend a little time talking about estate and gift taxes. Kansas currently does not have an estate tax. And when I say estate tax, I'm talking about like an inheritance tax. Kansas abolished theirs in 2009. It went into effect in 2010. And so we have not had one since then. I have heard no discussion and haven't seen anything of them planning to re-implement one. And so from that standpoint, we're good. Some states still do have an estate tax, although there are a lot of them now that have abolished. I think there's 30 some states, if I recall off the top of my head, now that have abolished a state estate tax. The federal government does have an estate tax. It is 40% right now, so it's a big one and it hurts. However, we do currently have an exemption amount of $12.06 million. Basically what happened is we had, if you guys have all heard of the Bush tax laws that sunsetted at the end of 2009. And so in 2010, we actually went for a year where we didn't have any estate tax, which is pretty amazing. There were some big estates that went through that year, but Warren Buffett could have passed away that year and they wouldn't have had to pay estate taxes. They did end up giving us two options before it was all said and done, but some big people ended up passing away money-wise. Ended up passing away and getting by without having to pay an estate tax. So, the Obama administration came in and they did put a permanent estate tax in place that year of $5 million plus inflation. So we have an exemption of $5 million plus inflation. The Trump administration then came in and they doubled that amount. So currently we have a $10 million estate tax exemption plus inflation. Which is great for those of us that plan, because it means we don't know what it's going to be from year to year until just a couple months before the end of the year. Sometimes not even then, depending on when they tell us. So makes it interesting. The Bush administration, or the Trump administration, however, did not make their doubling of that exemption amount permanent. So they are set to sunset in 2025, beginning January 1 of 2026. We will go back to the Obama era law, which is the $5 million plus inflation. So I do always tell clients, particularly my married individuals, tax planning can be very important, particularly in terms of a small business, depending on the nature of that small business and the assets of that small business. A lot of my clients out here that have ag property in particular, that's a really big deal because we have seen some insane prices on things out here recently. That can push them over for tax purposes and really cause a problem. So gift taxes are the other thing I want to talk about. When we talk about gift taxes, and I got off my slide a little bit. I just talked about this, the third one there, the sunset versus the proposed legislation. So gift taxes, basically right now we have two types. We have what's called an annual gift, well, two types of exclusions. We have something called an annual gift exclusion. That is currently at $16,000 per person per year. So what that means is I can gift up to $16,000 worth of assets to every single individual who's involved with this call today, and I don't pay any taxes and I don't file anything with the IRS, and they don't pay anything on receiving the gift either. Then we have something called the lifetime gift exclusion. That is currently equal to our estate tax exemption amount. So that estate tax exemption amount I talked about before, which is this year at 12.06 million, our gift exclusion is in the same place. So what that means is if I, and I'm going to use a rough calculation here, if I gift $1 million worth of property or use $1 million worth of my lifetime exclusion in 1 year, then I'm not going to pay any taxes on that as long as I'm below my total amount, so that 12.06 million. However, I am going to have to file what's called a 709 gift tax return next year when I do my taxes. What happens is if we have a $5 million exemption at my death and I've utilized $1 million of my lifetime gift exclusion amount, I am only going to be able to leave $4 million estate tax free at my death. So when I have small business succession plans, particularly if they involve family, a lot of the times my clients are looking to gift amounts to their family members. And in that particular case, it's really important for us to have all of that information and have those numbers to ensure that they don't go over the lifetime exclusion amount. If you do go over, you're paying the same tax amount that you are with the estate tax exemption of 40%. So it's a big tax and it hurts. I do always go ahead and point out some of the proposed legislation that we've seen. I always tell clients when I have politicians who are spouting things on the campaign trail, I don't worry too much about it. But once it gets memorialized and put in writing, then I get a little bit more concerned about it. Last year, it was about last May when that Build Back Better Act came out. President Biden started throwing around a $3.5 million exemption amount. Which it doesn't take near as much to get to $3.5 million anymore as you think, because things like your life insurance policies can count against you for those purposes. And he proposed a 45% tax up from the current 40% tax. That did get memorialized and put into writing last year. And so it's something that we want to make sure clients are aware of when they come into our office. However, it didn't make it to the Ways and Means Committee, let alone to the floor before it got dropped. So we don't anticipate that that would happen. What I will usually tell clients is if you and your spouse have an estate in the $5 million realm, we think there's a really strong possibility that, they don't have to agree on anything for us to sunset back to that law here in a few years. So we really recommend that you have estate planning in place that includes tax planning in that particular case. If we have clients in that $3.5 million to $5 million range, then you're in much more of a gray area. We don't foresee that we'll go back that low, but since it has been thrown around and placed in writing, it definitely makes me a little bit more nervous. So I always warn clients of that and say it's not a bad idea to have that consideration in place. Part of the reason that the tax issues are so important is if I have a small business and I have that 40% tax is something that's going to affect me, and my largest asset is that business asset, I'm looking at a potential either a forced sale of assets out of that business to be able to afford to pay for that, or I may be looking at the business having to borrow money in order to pay the tax, and that's a real problem. So it's another reason why it's extremely important to make sure we get planning in place and kind of have that done and taken care of. So. And then the last thing I just wanted to cover was kind of things for you guys to keep in mind. The first thing is that obviously the best planning is done in advance. My clients that wait until the absolute last minute, I have done those deathbed signings. It's never exactly how they want things, and it's not an easy thing to do. It's not a great thing to do. And like I said before, my clients that just decide not to do anything are the ones that we have the most issue with and really run into a problem. And then be aware of resources available to you. So when you have a small business, obviously There's a lot of things out there, a lot of resources out there to help. I just listed a few here. Some of these are some of your groups that are helping put on the discussion today. Review your plan and keep it updated is a big one. So my partner always likes to use the example that you don't turn 60, go to the doctor one time, get a clean bill of health, and then say, oh, I never have to go back again. And your estate plan and your business succession plan is very much the same way. So I always tell my clients, it's a good idea on your own, at least once a year, pull your documents out, sit down, read through them. If you haven't had any major changes, if everything still does what you want it to do, if you haven't heard from your attorney or your accountant or seen something that makes you nervous or received something that said, hey, if you meet one of these criteria, you really ought to come back in and look at making a change because there's been a real upheaval in the tax laws or something like that, then you're probably fine. Otherwise, I do tend to tell my clients once every 5 years is never a bad idea, just to stop in and make sure that there's nothing major that you need to have updated or done. Sometimes my clients that have business plans, it's more often than that, particularly if you have the type of business that you have a lot of changes on the regular. That can be an important thing to just maybe even annually follow up on, kind of like you do with your accountant in a lot of cases. So, and the last one is don't be afraid to seek legal advice or any other advice for that matter. Tax advice is a good one, legal advice, even advice from your financial planner, something to keep in mind and think about doing. So that was all I had because I thought, like I said, I was hoping we'd have a few more here so we could do some questions. I don't know if we're set up to do that online or if anybody has any questions or.
Yeah, if anybody has any questions, you can unmute, or if you want to type in your question, I'm able to view those.
Hi, Megan. This is Maria Dennison. First, I want to say thank you. I apologize. I was on unmute when I ended up getting a phone call. But I don't know if you covered it while I was in the other room, but my question is transfer on death. So I've understood the differences between having the will, having the trust, and kind of the differences between the two from a legal standpoint. But, and really more on the personal side, I understand that. When you have the business, does the transfer on death work in the same capacity? Is it the same concept when dealing with business? And I apologize if you already covered that.
No, it's fine. It's a really good question. So that would be something that we would consider to be part of a beneficiary plan. So a transfer on death can work. It oftentimes depends on the nature of the business. And what I mean by that is if I have a family-owned entity and we have done a transfer on death of my interest in that LLC and it just transfers it transfers upon my death back to a partner or back to my family members, that can be utilized. There's an argument there that if you have an interest that's over $40,000 in value, it should be probated. It's not settled, and so it can be utilized. I always tell clients, if I have a sole proprietorship and we've done a transfer on death designation that way, usually we're going to be fine and it can be utilized. It's not my favorite. And the main reason I say that is most of the time a transfer on death, what I will find is it will be something that is oftentimes not allowed under the organizational documents. And so if it's something that a client wants to do or does, particularly if it's in a multi-member entity, we want to absolutely make sure that it's something that we can do, because a lot of the times it will not be allowed under, particularly if we have a buy-sell agreement in place, or it won't be allowed under the organizational documents of the entity. So I hate to give you the attorney answer, but the truth is it depends on the nature of the entity and whether or not we're able to make it work.
So this is really vital then to make sure that when you're doing planning, not only from the personal side, but as well as in business that you might have, are they considered separate then? So for example, if I have a business and I realize that those organizational documents don't allow transfer on death, as you just said, and it's probably not the best fit, if on the personal side, all of those things fall into place, I can transfer on death, the mortgage, the bank accounts, etc. Do you recommend that personal and business are kept separate and there's two different sets of documents to look at?
So there are two different sets of documents to look at. You're correct on that. The way I explain it to clients is they're separate in the effect that I have separate documents, and what I can do for one, I may not be able to do for the other. But the way I oftentimes explain it to clients is that I have my estate plan, and my estate plan encompasses all of my assets, and my business is just one of those assets. Now, what those business documents say may control what I can and can't do with that particular asset. And that's why I tell clients, I think it's so important that if you come in or if you have a small business and you go to plan with somebody, you need to make sure that that attorney knows you have a small business. Because I do have those clients that just, oh, I forgot to tell you I owned an interest in this. That's really important for me to know if I'm making a suggestion on what type of estate plan I think would work best for you or what you should have. And then also makes a big difference on, we don't want those two things to fight against each other. And what I mean by that is I had a client who came to me after they had settled on some stuff years ago. But basically what had happened is my client had a mom who had set up an LLC and then set up a trust. And the LLC was set up with some of her farming children. And that LLC interest said it could not be transferred outside of her family. But then in her trust-based planning, she had done, mom had done, and this was, I'm gonna couch this by saying I was not the attorney that did this. But then in the trust-based planning that mom did, she left a percentage of her assets to another child that was not involved with this entity, which is fine, except that this entity was her main asset. And there was no way to transfer a percentage to that particular individual without transferring some of this entity interest. And the entity said that that individual couldn't be an owner. And so that causes a real problem. And so it's why it's so important to make sure that the two work together. So there are some cases where I am able, particularly in sole proprietorships, if somebody just wants to do a transfer on death on their interest in that sole proprietorship to their family, because their thought process is that entity is just going to be wrapped up upon their death and basically become part of their estate plan. And so in that particular case, that's something we can utilize and it might work just fine. But if we have somebody who has ownership interests in a multi-member entity and they've got a document that says you can't make this transfer, that we want to, it's not that it means we can't utilize the estate plan that we want to, but it may mean that we need to adjust for that particular asset under that estate plan.
Okay, that makes total sense. Okay. And it looks like there's a question in
There's
the
a
chat.
question. Yep. Tanya said, I have intellectual property and am a sole proprietor. If I create a trust describing who is to be in control of specific aspects of the business, can I just list on the will, please see the revocable trust so the details of the will stays private?
So I want to make sure I'm covering right. So here's the issue, Tanya. If you have a trust-based plan, I always tell clients, if you, because I'll have clients who will say, well, can I do a trust and just leave these assets out and do them differently? Well, you can, but I don't know why you'd pay the money to do a trust and put that planning in place and not have that trust cover what you want to happen to that asset. So when we do a trust, we typically have something called a pour-over will, which is just a fancier word for another last will and testament. And the question I always get is, if I have a will, or if I have a trust, why do I need a will? Well, we call it a pour-over will because it says that you have a trust and that you want all your assets to go to that trust. So typically that's what your will would say. And what I would recommend, Tanya, is that then under that trust, you would just have a specific provision for that asset. And yes, then you could name who you wanted to be in charge of that intellectual property. You could have that property held in its own separate sub-trust, even upon your death, that would be established, and say who would have control of that and how that would be utilized. Kind of like I do with a lot of my clients when they have what we call farming trusts, where we'll have all the land. Can you tell I work with farmers a lot? We'll have all the land go into a separate trust by itself. The other assets go ahead and pass, and then have specific provisions as to that land because they're maybe wanting to keep something together so a child who farms doesn't lose their livelihood. So that's typically how I would recommend they work together, rather than that you have a will that handles just one asset and then a trust that handles everything else. I would kick it all in with that trust and have it done that way, so that nothing has to go through the court and it does all remain private.
And Megan, when you do when you set up that trust, that means nothing's going to go through probate, correct?
That's the idea. Yes.
That's the idea. Okay. And then, and the biggest, I guess the con they say of the trust is the fact that you're going to have to take all of those assets and then change the ownership, correct? It would now read whatever the name of the trust is, correct?
And that is one of the biggest downsides. And like I said, it's more expensive up front because you have to retitle it. And that's just kind of a pain in the hiney. Nobody enjoys doing that. I get it. That's what part of what you pay us for in our office, is to help with all of that. But the other thing is, I always tell clients, it's important to remain cognizant. And what I mean by that is, if I have a trust-based plan and I am buying a piece of real estate, or I'm opening a new bank account, I need to remember to do that in the name of my trust. In our office, we do everything we can to kind of help you remember that. I make these little trust ID cards you can carry in your wallet that show clients exactly how anything in their trust should be titled, and have my phone number so they can call me if they need me to send something. I always tell clients, I don't charge for that because I want to encourage clients to keep their trust funded. But yes, that's the idea behind it, is to have everything flow through that document so that you don't end up with a probate. I have had a situation years ago, probably it was so unusual that I doubt I would ever see it again in my career. It's kind of shocking that I saw it at all. I had a client who had done trust-based planning, and her dad had passed away, and he had a will-based plan that was being handled by a firm in another town. And as I said before, it typically takes 9 months to a year on average to settle a will-based probate when it's all said and done. Just a lot of hoops. It's interesting. Our court calls our probate process a simplified process, and I don't think there's anything very simplified about it. But anyway, about 6 months after he passed away, she very unexpectedly passed away. So it was one of those very unusual situations where she had to inherit from him because she survived him by so long, but she hadn't received it yet because they were still going through the probate, and she's no longer alive now to title and place those assets into the name of her trust. There are some, whenever we do trust planning in my office, there are some safety net documents that we put in place and do to try and avoid that scenario. That pour over will that I spoke to Tanya about earlier is one of them. That allows us to get the assets into the trust, but the pour over will would still require us to probate that will, and I like to avoid that process. So we have another document that we do in our office called a declaration of trust. It's based off some Kansas Supreme Court law that basically says, hey, by signing this document, which says I want anything that can be owned by my trust to be owned by my trust, you have effectively conveyed your property to that trust. And so what happens, and what we were able to do in her case, is we were able to, since that pour over will had been filed, we were able to then file an order. We call it a Taliaferro order because that's the name of the case. And it doesn't even sound like a Kansas case. It sounds like it should be from Chicago, but it's not. It's a Kansas case. But it's just a declaratory judgment order that we file with the court, and we basically say, hey, this asset has already been effectively conveyed to the trust judge. We just need you to sign off to actually retitle these assets. And so, like in her case, we were able to do that, and it keeps us from having to do the full-blown big expensive probate. I don't have to publish anything in the newspapers when I go that route, or mess with any of that mess, quite honestly. So we do always like to have those safety net things in my office when I do trust-based planning, to hopefully completely avoid, the idea is to avoid any court proceeding whatsoever. But if we have to have a court proceeding, that is the preferred one, because it's a much less expensive and faster proceeding. We don't have any required timelines or anything that we really have to mess with in that case. So.
And Megan, if somebody is looking to go through that trust process, either personally or for their business or both, what does a time frame look like on that, from kind of just an estimate of start to finish? And I know that probably depends a lot on the assets.
Well, it depends on the assets. And then a lot of the times it does depend on the client. In a lot of my cases, I always tell my clients, I don't mind if I'm waiting on you, but I don't like you to be waiting on me. So in my office, we try to move relatively quickly, if at all possible. Most of my clients that come in to do estate planning, we sit down, we have the initial meeting, we talk about all the options. I will say my clients that have small businesses, a lot of the times it's not unusual for us to need a second meeting, because if they have no planning in place for that business either, a lot of the times that ends up being more than one meeting before it's all said and done, to make sure that both work with one another. But basically what we do in that case is I usually try to, as soon as a client has decided what they want to do and they're ready for me to move forward, I will try to have documents drafted and back out to them for review. I typically try to do it within a week when I can. I always beg a client to give me 2, just in case it's been like it has lately, which is a little bit crazy. But otherwise, we try to have documents out to them relatively quickly. And then it's just a matter of how long that client wants to take to review. Most trusts in my office, we will usually have everything pretty well done and in place within a month, if at all possible. And we might still be doing a little bit of that funding. Like you said before, the nature of the asset sometimes will make that take a little bit longer, but we try to get all that information from the client up front, so that when they come in to sign their documents, we've pretty much got letters ready to go to all their financial institutions and their banks, and forms for their life insurance policies, and all their deeds done, and any transfers or documents that we're doing on the business. Try to have all of those done at once when we can. But then we, like a lot of my clients, one of my least favorite, anybody with producing minerals, those companies will take 6 months sometimes to issue a division order back to us. It's like they're just on their own timeline. So it does sometimes depend on the nature of the assets, how long it takes to get something done.
Okay, so basically what you're saying then, and this is my little naivete where this is concerned. So when somebody's coming to you to do estate planning, you're literally not only drawing up the documents, but you're putting into place all of those things that have to happen to get those changes, like to go from where your mortgage is currently written to now it being in the trust. You create those documents to go to the asset holders.
Yeah, we try to take care of everything and do it relatively quickly. Yes.
Okay.
We had one more question. And speaking of a will, if a new will is drawn up, does the court keep a copy or just record that one, what's created?
So we don't file a will with the court unless somebody has passed away. It is not filed of record anywhere until somebody has passed. And then in Kansas, we have what is, I think, quite honestly, kind of a silly little law. We have 6 months after somebody has died to then file that will with the court, even if all we're doing is preserving it just in case we should need it in the future. I think they do that because there's like a $70 filing fee you pay when you file it with them. And I think it helps keep the state funded some on some of that stuff. But yeah, there is nothing that's filed. So if we're making a change to a will and somebody's still alive, obviously for us to do that, that isn't anywhere on record other than with them in my office typically.
Megan, is it also typical that, and I've heard this happen, where people have either misplaced their will or something has happened, they can't find it. Is it normal practice for an attorney to keep a copy of that?
Yeah, so we don't keep originals in my office. I try not to. I try to always have the clients have the originals and just keep copies. But yes, typically the attorney will have copies, and we can file copies of just about anything. Even a will, we can usually file a copy of a will. The paperwork is a little different after somebody passes if we're filing a copy and we can't find the original, but we can do that. I had a client several years ago who, bless her heart, she had a dementia diagnosis. And when her daughters, who didn't live out here, but when they came out to help her finish cleaning out the house in order to move her back closer to them, they discovered she had been throwing away items in her house, and they assumed her estate planning book was among them because we never did find it. And so that was a situation where we were able to just file a copy of the will. And we do keep copies of all of that in our office. I keep them, I'm old school. I do keep them electronically, but I still like my hard copies. So I keep both in my office.
Okay. All right. Well, thank you. I appreciate that.
Yeah. Awesome. All right. Well, thanks, Megan. And then I will follow up with an evaluation in an email this afternoon. If y'all could fill that out and return it, I'd appreciate it. And thank you so much. This is awesome.
Well, thank you for having me.
Thank you so much. We appreciate you coming, Megan. It was great information.